Well, today being Tuesday, June 11th, in the Civil Rights Conference Room, looks like we have roll call all set up. Make a motion to approve the agenda.
Approve.
A second.
Thank you. Moving on to approval of the minutes. Motion to approve the minutes.
Do we have to approve them one by one, or
Have we had a chance
No.
to just?
the whole thing?
Yeah.
Yeah.
We have a
I'll
second?
move to approve the minutes.
Second.
Thank you. I'm going to move to the director's report.
All right. So we had one right to sue letter that was issued in the month of May. Does everybody know what the right to sue letter is?
Can you?
It's, so if somebody does not want to proceed through the administrative process, they can request a right to sue letter. And then after chapters, the case is verified, they can just request a right to sue letter, or not wait for the investigation, or really any time throughout the process, as long as the case is still open and no probable cause decision hasn't been issued, they can request a right to sue letter. This case was a we had issued a probable cause decision, and the complainant came in and requested a right to sue so that they could pursue the action in federal court. It was this is a public accommodations case. We have one employment case that's settled in conciliation. Conciliation occurs after probable cause decision has been issued, so we have mediation before a decision has been issued, and conciliation after the decision has been issued. It's settled for $10,000 and it was a public interest. So this was a case where the complainant had previously filed a complaint in our office, and after that case went to public hearing, and then immediately after the commission issued their final decision on it, he was fired. So he had been rehired after he filed the complaint. He'd been fired, then rehired when he filed the complaint, and then when the commission issued their final decision, he was fired again. So he filed a retaliation complaint, and that resolved for $10,000. We started working on our back to school event. I don't know if I have explained our back to school event already.
Tidbits. Yeah.
School just ended.
Back to school. So we, every year we do a back to school drive. I think this is our 4th year, so we usually partner with other city departments and community partners. The first year we did these events, we call them Peace in the Parks. So we went every month to a different park. We tried to find parks that were in kind of lower income communities, just to have like a fun event that was free, safe for kids to go to. We have our little cotton candy machine that we searches for outreach activities. And so we have like cotton candy and popcorn, and kids can come join the park, they can interact with police officers, the fire department, other city departments. The library usually comes and brings out Legos and different things for the kids to play with. That took a lot of time to do the 4 events, and then the final one we had a pool party. So we did it, I think we actually did it 2 years like that. But the 3rd year we did it, we did 3 events at different places, and we partnered with other people who wanted to have a school supply drive. So we went to Beyond the Baseline, United Neighbors, and the library, and we had 3 different events in 1 year, and we just went to their location and passed out the school supplies. We usually partner with either a community organization or the first 2 years we partnered with the State of Iowa Youth Advisory Council, and the team from that event, she got together with friends from Bettendorf High School, and they collected clothes to give out. Last year we partnered with, the last year and the year before we partnered with Stuff, so they gave us quite a bit of stuff to give out. So we had clothing for the whole family and shoes, and then I usually beg my friends for gift cards for socks and underwear so that we can give out new stuff. So That takes it takes a bit of time, but it's, I usually do that after work. So that's not really commission time, but, I go around and purchase, items to give out, for that every year. So the year before last, we got almost 1,000 backpacks and school supplies to fill them all.
Wow.
So we had like 300 left over, so we used those last year, so that we could finish getting all of that stuff out. And then this year now we're back to begging again, so if you know anybody that wants to help it, feel free to join in and volunteer with it.
Now, is that tied to certain, I know you said, is it just citywide, do you tie that to certain schools when you're trying to do give
Whoever
backpacks
wants to
away?
come, yeah.
Okay.
Whoever wants to come. We do it as a fair housing initiative, to allow people to come out and get to know their neighbors, to kind of build stronger communities. It gives them an opportunity to meet with city departments outside of the conventional structure.
Yeah.
And get to know us. So we do we usually put on a fair housing play. So we have a coloring book. We have a story that we had an intern write, about our fair housing, a fair housing, dolphin who's, discriminating against people, the discriminatory landlords, dolphin. And they don't like the colorful fish and the big school of fish, there's too many fish. So we have a student usually volunteer with us to kind of go through and read through, play out the parts. So we do that presentation, then we put our information in the backpacks. We usually have pencils and pens that have our contact information on it, as a way to kind of get the word out about our office, but also as something that's like community oriented and get people getting people to get to know each other a little better.
How is this marketed?
We usually just shoot it out through the media, put it on Facebook, Twitter.
It's on the city website too.
Yeah, city website, on our page, and we just send out press releases to the media.
And our engagement's been pretty.
Oh yeah, the first
Turn out, yeah.
the first year I was like, oh, we'll get enough stuff for 100 people, and like 2,000 people showed up. I was
Yeah.
like, oh, okay, maybe. I don't know if we'll ever have that much, but yeah, people follow it, and so the last year and the year before, people were just calling the office afterward, like, do you all still have anything left? And they would just come down to the office and pick up backpacks and clothing. So it was really, the partnership with Self was really good because they gave us they loaned us racks, so we could set it up like a store. And so people were able to come out and go shopping, and it's like a free experience to go
That's
shopping.
perfect.
I was very surprised the kids were like willing to jump in on getting like used clothing, but they didn't mind.
Is
They were
there,
willing for it.
we have a sign up for volunteers and,
Mhm.
okay.
You want to sign up to volunteer?
I actually, yeah.
All right. We've only had one meeting so far, so.
Yeah, be careful scratching your nose.
When do you
Sound
usually
like
have
an
it?
auction.
When do you usually have it in place?
We usually do it the weekend before school starts back. And this year, I think it's, I want to say August 24th.
Yeah, that's the week before.
We work with HUD and Department of Justice on a fair housing initiative stage transport. So we have, HUD is doing an initiative for sexual harassment cases. And we had a case that there's information that we obtained during the investigation that looks like there may have been sexual harassment, that it may have occurred, it may have been pervasive, it may not have just been the one person who was involved. So we are working with HUD today to see if that's one that they want to pursue, or if they want to leave it with us and just let us try to resolve it. We do have two cases that are currently in litigation, so we're working on those and working with the other attorneys on getting those, figuring out next steps. We have another case that, well, it's not a case we have. There is a complainant that contacted us about an issue regarding sexual assault. But it occurred outside of our statute of limitations, so the Department of Justice has a different statute of limitations for when they want to pursue sexual harassment, sexual assault cases in housing. So we're working with them on figuring out the exact statute of limitations and whether or not this person can take their case directly to them to pursue it, and how they want us to process that, if it goes through HUD first or if it goes through the Department of Justice first.
That's not, the police are not involved, or?
It's, it happens differently. They reported it to the police, but it doesn't look like anything happened as a result of it. If the Department of Justice takes it, they can go forward and press criminal charges.
So the county, has the county attorney to refuse to pursue it, or they just, it hasn't gotten to them?
No, the person reported to us that they reported it to the police, and they didn't feel like it was taken seriously. And nothing happened as a result of their report.
So, do we have a relationship with the county attorney that, like, we can give them that information? Because they're the ones that are gonna decide to bring the case or not. They should be.
We wouldn't usually do that.
Okay.
So the commission has the authority to bring criminal charges, but it would go through the Department of Justice, and they would do it as a 901 case. So there is the authority through HUD to bring criminal charges, and through our ordinance, but we wouldn't usually do that. It would usually go through those other channels to pursue it. And we don't want to create the appearance of us like advocating for someone.
Yeah.
So we usually don't go forward and like try to force any other agency to take any action, or try to encourage any, I shouldn't say force, but encourage any other agency to take action on it.
Yeah.
And it also brings up like confidentiality issues, because anything that's filed, you're not supposed to disclose it. So it brings up a lot of different issues with figuring out which way that it goes.
What is the statute of limitations, and how different is it from the one that you referenced with HUD?
DOJ is,
Yeah.
they have a different statute of limitations, and I'm not sure how it's calculated. So the statute of limitations for HUD is a year, for our office it's a year. But the Department of Justice has a 3-year statute of limitations, and I'm not sure if it's 3 years after the 1 year, or if it's 3 years total.
Okay.
So
Thank you.
figuring out what how that process works, but the last conference that we went to, they encouraged us to not turn people away if they come in with allegations that are outside the statute of limitations, because of this difference in their statute of limitations, especially relating to sexual harassment cases, because that's their big initiative that they're working on this year. We're finishing up our annual report. It's super late this year. The staff room that usually does it was out, and we have been short-staffed for most of the year. So we're finishing that up. We do have somebody that might want to volunteer to work on an equity report for 2019 for us. So we're going to be working with them to see if we can get a state of the equity for the city of Davenport report done. We had 2 cases that were transferred to HUD. After we finished they were related cases. One of them was the person had filed a complaint, I think with our office, and it got transferred to HUD maybe like 2 years ago. And then their daughter, the daughter was being retaliated against because of the mom's complaint. So she filed a complaint in our office, and then the mom was being retaliated against for her previous complaint and the daughter's complaint. And so they both filed new complaints, and after we finished the decision on one, we learned that there was an appearance of a conflict of interest, so we transferred those both to HUD because of, there was some involvement from city staff, and so we didn't want to have that be an issue that comes up. The DCAP is just the community advisory panel that's working with the police invested the racial profiling study. They are working on getting out their public meeting, the information about the profiling study from, I think this is the data that they're reporting on is either 2016 or 2017. I don't think there's a date finalized yet though for that, so when we get a date, we'll send it out to everybody in case you wanna attend the meeting. Litigation appeal, that's our fair housing case, it's on appeal to the Supreme Court. So, waiting to get additional information about that. The FIFA conference is our EEOC conference, so that's later this month, it's the 18th through the 20th? Yeah, the 18th through the 20th, and it's in San Diego, so I'll be attending that, bringing back lots of material in case anybody wants them. I think that's it, I have going on.
I noticed that there was, I guess, I don't know the trend, but there were 16 open cases last month?
27.
27. And year to date, there are, did I see 60? I could have been looking at a different cumulative. But it seemed high.
Yeah, we get all this free publicity, so. That's how many have closed.
Okay.
60.
60.
Year to date. And then there's 16 that were closed last month. But we had 27 filed last month, so that's a lot.
Yeah.
It's above normal.
Yeah.
Like you mentioned, even compared to Des Moines, it's even larger markets don't quite have the amount of cases that we do.
Yeah.
And they have more staff to handle those cases than we do.
Yeah, because it's very limited staff there.
Yeah.
Just have more discrimination in Davenport, no, I'm kidding.
Probably true though.
Well, I think it's probably what Latrice is saying, the knowledge factor. People know that the office is here available. I'm quite sure it's pretty much comparable everywhere.
The number of cases?
Well,
Or
the number of
discrimination?
incidents, exactly. Unfortunately, I think the incidences are probably the same nationwide.
We do have a weird, we have some weird demographic data about equity in Davenport. So it does look like there's, I don't think it's comparable to other cities our size,
Okay.
the disparities that we see.
Yeah, looks like that was it. Moving on to new business.
We have to have a motion to.
Yep.
I move the director's report to be approved. I second.
You have to take a vote.
All in favor?
Aye.
All opposed? Motion approved. Moving on to new business.
All right. So, I met with Ruby, Michael, and Erie, since they're new officers, to go over kind of the stuff that they do outside of the normal commission process, with like submitting minutes, and Ruby and Michael will be my contacts for things that are coming up or going on in the office, so those kind of things. But we also talked about stuff that maybe we needed more information on. And we should probably meet maybe, I know you have to go today, but maybe after today to go over things that you feel like you might need more information on.
Sure.
But I wanted to catch them before the meeting so that they would know what to do for before this meeting. But we should probably touch bases on it too to see if there's more information. So, one of the things that we talked about were was the chapter 21, 22 information, so open meetings and open records. And then kind of the legal aspects of boards and commissions. So this is, I did not create this. It's borrowed from the Attorney General. So their legal overview for board and commission. Can everybody see this over there?
Yeah.
Okay. So the boards and commissions are obviously created by statute, just called the Enabling Act. So this commission is created by the Iowa Civil Rights Act, which is Iowa Code 216. And then it's governed by the city civil rights ordinance, which is 2.58, which is in the book. Both of those are in the book. You only have the authority granted by law, guided by the law, in addition to the law that creates the board. So we're guided by our city ordinance, but also by the state law that created the agency. And just for reference, the state law is any city that has over 29,000 people has to have a civil rights commission. And this is just an example of a code section that gives the duties and powers for professional licensing boards. But boards can't expand their authority beyond that if granted by law. The law may be very specific about how decisions shall be made or grant board discretion within specified limits. So our ordinance says that it should be broadly construed to effectuate the purposes. So the commission has authority to interpret the ordinance in the way that they feel like would effectuate the purpose of the civil rights ordinance. Oops. This is what I was afraid of. Okay, so make sure that we read and reread the laws governing the board. Our ordinance is a little wonky, so if you have questions about how something is interpreted, feel free to ask me. And we can do some research on it, because there are a lot of things in there that I'm like, I don't know what that means. Let me figure out what what they were referencing when they wrote that. Especially our housing ordinance, it's copied after the Fair Housing Act, but when they formatted it, they didn't format it exactly the same. So it came out in, there's like portions of the Fair Housing Act that it's like one section, but our ordinance is separated into 2 or 3 sections, and so it doesn't flow the same way that it's supposed to under the Fair Housing Act. If you don't know what it's copied after, it looks like it's referencing like 2 or 3 different things versus just the one section that it's supposed to be. I think all of you have probably looked over prior minutes on the website and all that stuff, so cover that for information. Board terms are staggered for a reason. Obviously you want new board members to have old board members to get information from. Don't rely exclusively on what others tell you about the mission of the board or its authority. Check for yourself. The board's mission is always a public purpose. When serving on the board, you're representing citizens of Iowa, so we have to make sure that we're inclusive and that we're listening. And we're making decisions with a public purpose in mind. So we might have personal feelings about how something is or it's interpreted, but we should be doing it based on what the law says. So it's past you now. This is just a copy of this that's on the screen. Most boards have, and this is based on state, so most boards have rulemaking authority. This board has rulemaking authority, so when I mentioned that the commission is a quasi-legislative body, that's what I mean about the rulemaking authority. So the rules are how the commission would operate. They're authorized by and consistent with the statute. So the Iowa Civil Rights Act states that local commissions are to create rules under Chapter 17A of the Iowa Code, which is the Administrative Procedures Act. And then our ordinance authorizes the creation of rules for the interpretation of the chapter. So the rulemaking is council authority. It describes the organization and procedures of the board. It states how the board will implement the laws that it's enforcing, and it informs people about the guidelines and policy choices that impact their legal rights and duties. So let's say an attorney wants to figure out how, attorneys usually are the ones that go to look for the rules, but let's say they want to file to have a case closed or have it dismissed. There would be rules to explain how you should go about filing to have it dismissed and how it's ruled on and how that's interpreted. Right now we use these, we kind of rely on the Iowa Civil Rights Commission's administrative rules to figure out how to do things and operate based on those, since we don't have official rules approved. When everybody decides they want to sit down and review the rules, we'll figure that out and do public hearings for that. It's a project, so. But we do have them already drafted, they're just need to be voted on and have the public hearings for it and everything, so maybe we'll plan ahead for that. So the rules are supposed to be kind of easy to understand and, so like the portions of our ordinance that are like maybe a little wonky and don't make sense, the rules could explain what it's supposed to mean and how it's supposed to be interpreted. We shouldn't have things in the rules that are unduly burdensome, so we don't want the cost to outweigh the benefit. They should be effective. We want to make sure that the people who are impacted by the rules are giving input and that we're considering that input. Make sure that they're fair, so the rulemaking authority should be used wisely. No single board member makes decisions for boards, so they make decisions by taking votes at board meetings. A quorum of the board is required to take a vote. It might be a majority, 4 out of 7, or it might be 2/3, 5 out of 7. So the enabling act usually state what a quorum is. So ours says that a quorum is majority. Once a quorum once we have a quorum, the board action is taken upon a majority vote of those participating. There are important exceptions. Can only go into closed session. We have a public vote by 2/3 of the members or all of the members present. So we only have 4 members. If we have 4 members present, we don't have 2/3 because that would be 5 of 7, but everybody would need to vote to take it. This one isn't really a requirement for this one because we don't, well, maybe. Discipline can only be imposed on a licensee by a majority vote of members on a higher percentage if required by law. So sometimes we have landlords who have a rental license, and the commission might, as part of their ruling, rule that the person can't be a landlord anymore. So that could be a ruling on a licensee. And that's once it's gone public, the commission has issued a ruling, we would usually contact Public Works to let them know that the commission has ruled this about the person's license. This is the action that should be taken on it.
And is that, so if you have ABC company, you're the landlord, are we ruling against the company, or are we ruling against the actual shareholders or whatever, owners of the company?
It depends on the fact. So like, I think it has been done once before in recent history. The landlord was raping the tenants. And so he and his wife owned a bunch of properties. And so the wife was kind of complacent. I don't know what word it is. Like, she knew about it, but she wasn't doing anything to try to prevent it or stop it. And so the ruling was that they were not allowed to be landlords anymore. So they couldn't have any sort of ownership, or they weren't allowed to. They could rent the property, but they had to hire a management company to manage the property. They weren't allowed to like be directly involved with tenants.
Okay.
And it was against both of them. But they could still rent things out through this third-party management company. The votes of all members must be public and clear during the meeting and in the minutes. So we only take a voice vote when the vote is unanimous. We use roll calls whenever the voting to go into a closed session, or when a member abstains or votes nay. We don't want to use secret ballots. I'm not going to write down votes. Inviting the public. So if there's a majority of the board present, either in person or electronically, we're not supposed to discuss board business unless you are at a board meeting preceded by proper notice to the public and a posted agenda. So this was why I was terrified of the meeting that purely social or ministerial gatherings are not meetings as long as no board business is discussed. But you have to be careful to even avoid the appearance of holding an illegal meeting. Agendas are a board's invitation to the public to kind of watch what's happening, so we have to post those at least 24 hours in advance. Identify all of the topics that we're going to be taking action on and matters that are going to be discussed. The detail needed in the agenda is kind of based on the public's familiarity. That's still wrong. The less familiar the public is, the more detail is needed. So kind of read over the agendas for the last year and see if you can figure out what we were talking about, and that might give input of whether or not we need to create more detailed agendas or have more information on the agendas. We have to stick to the posted agenda. If a new idea comes up, and there is no emergency requiring immediate action, that should be placing that topic on the agenda for the next meeting. The public has a right to observe the open sessions, and they can record or take photographs. The public does not have a right to participate in meetings, but boards typically will give you an opportunity to have public comment. This goes back to boards and commissions having the authority to decide how their meetings are conducted. The minutes create a permanent record of who met, when they met, what they discussed, what was decided, by what votes. So we need to make sure that we have accurate minutes. We're conducting public business so that that's open and accountable. They're a vital organizational tool for boards. They are a crucial way for citizens to review public action taken on their behalf. Minutes of open sessions always include the date, time, and place of the meeting, which members were present, actions taken with sufficient information to reflect the members' votes. Again, you can read over the minutes over the last year and see what we voted on or discussed, and see if it provides sufficient information. If there's a closed session held, the minutes of the open session include the legal grounds for going into closed session, and then it records the votes of each member and whether or not they voted to go into closed session. And then any final action that was taken, that goes in the minutes as well. But the minutes for closed session are separate from the minutes for open session, so they go into the file for the closed session recording. No final vote can be taken in closed session. We may have closed sessions sometimes where we don't take a vote. It might just be that I'm giving information or legal update about something that is not open record, it could be a case or something. When applicable, minutes must also explain the legal basis for holding a telephonic meeting, an emergency meeting, or a meeting at a time or place not reasonably accessible to the public. Closed sessions are serious business, so we should never ask the public to leave so that we can talk private, unless it's an actual closed session and there's a legal basis for going into closed session. In order to go into closed session, you have to first meet an open session with the proper advance notice and posted agenda. Sometimes we will have something on the agenda to go into closed session for that we don't specifically say what it is, because if we say what it is, then it might give notice to a party who is involved, or might be involved in wherever the issue is. And that's an exemption under the open meetings law, which I also forgot to pass around. So that's chapter 21 and 22.
There you go.
You can only choose an open session or closed session if expressly authorized by statute. That's an error. They can go into a closed session to discuss pending litigation with counsel, personnel matters, whether or not to initiate disciplinary action with the RTC. Always check with your boards. This is Assistant Attorney General. I am the attorney assigned to this commission. So check with me if we're not confident about grounds to go into closed session. So after we announce the legal basis for the closed session, take a roll call vote. Usually that's what we'll have on our agenda is we're going into closed session pursuant to section 22.7, what is it, subpoint, what is it? Let me see if I can go on it. Subpoint 5. Let's see.
Which one is the closed session?
Yeah. 22.7, and it's usually 5, I think, to discuss a decision. So then there's a roll call vote of that. It goes into the minutes, obviously. You have to record the session and keep the recording for at least a year. Take detailed minutes, and there can only be discussion of the that relates to the announced basis for the closed session. So we can't get in the closed session and start talking about something else.
If going into closed session requires public notice, in basically an open session discussion, how do we announce it?
It doesn't, so it goes on the agenda,
Mhm.
so that's the public notice of it.
Okay.
And then what's announced during the meeting, and we're gonna go into closed session pursuant to chapter 22.7, whatever the code section it is.
Gotcha, you just leave it at that.
Mhm.
Okay.
And then once we get into closed session, that's when we talk about whatever we're there for.
Gotcha, okay.
Again, the final action has to be taken in open session. When the closed session discussion is finished, we return to open session. And if people are like waiting outside for us to finish closed session, they can come back in and then make a motion to take the vote for final action in open session.
But that's not always required, though. To vote for final action.
We might not take a final action, I might just be up late, and it might just be like, we're about to get sued. No, but it might be like something coming up or some, or I'm trying to think of a scenario where, okay, so we had an issue where there was a concern with a case that had been closed, and the attorney for one of the parties reached out to me and expressed the concern, and so then we went into closed session to discuss that it was gonna be an upcoming issue, and that, just to be aware that this was gonna be something that was gonna come up and could result in litigation. Public records. So board records are open to the public for examination unless they are specifically made confidential under the law. So under our ordinance, all of our records are confidential related to cases. So they're not open to public examination. Emails that are relating to cases are not public records. Emails that are not relating to cases could be public records. Board members should not commingle official board business emails with personal emails. The board staff or assistant attorney general can assist on methods of separating emails. So let's say you have an email with another commission member where you're talking about lunch, but also case, kind of commingling that personal lunch message with a case message, and so then that could be a public record. Assume any record you create or receive as a board member is a public record, and may be open to the public upon request. Only say what you'd be comfortable reading on the front page of your local newspaper. Bill. Find out who the public records contact is for your board. The contact person or the lawful custodian is most likely the board's executive officer or administrator. So the city's public records custodian is the clerk. The things related to our office, the FOIA goes to the clerk, and then they send it down to me, and then we figure out what needs to be released. Find out if any of the records we create or receive are confidential, and that's in the ordinance, and I don't want to cite it to the wrong section, but it's towards the beginning of the ordinance where it talks about the confidentiality of the complaints. Sunshine law enforcement, so if there's an action to enforce an open meetings or public records law, that could be brought by a citizen in the state of Iowa, a person who pays taxes to the state of Iowa, or a person individually aggrieved by a violation, the county attorney or the attorney general. And those actions can either be brought in court or they can be taken to the Iowa Public Information Board. So any complaints about alleged violations should be made directly to the board, its staff or council, the ombudsman's office, the attorney general, the governor's office, or the Iowa Public Information Board or legislators. Those allegations should be taken very seriously. The remedies can include removal from office if it's a second violation, damages up to $2,500 for an intentional violation, expenses and attorney's fees and injunctive relief. By and large, public officials will comply with those sunshine laws when they know what they are, so to make sure that we know what the open meetings, open records laws are, and that we're complying with those. Because even an honest mistake could be a violation of the sunshine laws. But you can avoid individual liability if you're relying on advice of counsel, formally given in writing or provided orally and memorialized in the minutes. And there are a ton of sunshine advisories to educate public officials and the public about open meetings laws. So if you go to the Attorney General's website, you can go to sunshine advisories and it'll show you all of the different advisories that have been issued over the years. And you can also contact the Iowa Public Information Board and look at their website. They have sunshine advisories information there as well. So I talked about the commissioners as quasi-judicial officials. So you all serve as judges when there are cases that come before the commission to decide for final agency action. So we have hearings. The commissioners don't usually conduct the hearings. They're conducted by an administrative law judge. After the administrative law judge issues their decision, it goes back to the commission to issue their proposed decision. It goes back to the commission to issue a final decision. And this relates to the Iowa Code of Administrative Judicial Conduct. So this is for administrative board commission members who serve as judges. So that's the rules of conduct for that. An independent and honorable administrative judiciary is indispensable to the justice of society. So you have to make sure that all parties are unbiased, that are getting fair treatment, it's free from improper influences of family, social, political, or other relationships, or prejudgment of the facts. All decisions will be made solely on the record in the case. Board members shall not communicate with the party to the case without notice and an opportunity for all parties to participate. So that's what would be called ex parte communication if somebody were to contact you outside of the official process regarding a case, or to talk to you individually rather than having that communication with everybody coming to a commission meeting and stating something that's different than somebody, let's say, finding your email online and emailing you about their case. Board members can't personally investigate facts and then sit in judgment of those facts. So we have, these are the additional laws that govern board members. So we have to worry about the gift law. So let's just avoid accepting gifts altogether. I think it's like $3. So receiving something for free or less than what it's worth is what is considered a gift for many of the entities that are regulated or contracted with our office. If you sell or lease goods or services to those regulated by the board, I would say ask the Ethics and Campaign Disclosure Board for guidance on applicable laws, because I don't know, I'm not well versed enough in this to give anybody input on whether or not that would be an impermissible thing. If we're doing any sort of lobbying, which we're not supposed to do, so let's just not do that. That would be a violation of our federal contracts to engage in lobbying. So yeah, avoid conflicts of interest. How and when they arise can be unique to certain boards. So let's say you have you find out that there's the case that's being considered is your brother is involved in the case. You need to remove yourself from the closed session and not have any involvement with the decision making on that case because it would create a conflict of interest. Everybody wants to believe that they're neutral. Judicial review. Our final agency actions are reviewable to the court based on our ordinance, based on state law. It has to be compliant with the U.S. or Iowa Constitution, statutes, or rules. It has to be consistent, non-arbitrary, logical, and reasonable, and supported by the facts in the law. If your board is controlled by those it regulates, be especially cautious about actions that may impact competition. So 68B kind of goes over the conflict of interest and gift law. duties, complaint procedures, the personal finance disclosure, that information about kind of understanding the ethics of serving on a board or commission or government official, I should just say, and not having that conflict of interest. I think it's $68B 22 is the gift law.
Yeah.
But make sure that you review these for the information that we might be missing from the training. Is there any other information that might be missing that would be helpful for the next one? Okay, well, we're done.
As far as additional training, this kind of leads into an idea I had where now that we've been given this information, we should, I guess I should back up. Members of staff, as well as other areas of the commission, they have evaluations taken care of them to make sure that, and we evaluate them. So we evaluate staff, make sure that they are up to a certain standard. I don't think it's unreasonable to say that we should also have some sort of evaluation, but currently the commissioners don't have one. So I would like to say that now that we've been given this information, we go ahead and create that sort of standard for future commissioners, but in addition as well for ourselves. I think the public will probably appreciate it. It kind of gives them the heads up that we are knowledgeable in what we're doing. And that we can feel confident in going into closed sessions with one another. Your thoughts on that?
I think can we put it on the agenda for our next meeting?
Yeah,
Yes.
yes. So just a
I'll
topic
agree
now.
with that. Cause I don't know, we can't discuss that right now, I'm assuming, yeah.
It's just a topic.
Yeah,
But
yeah,
then,
yeah, I agree with putting it on the agenda for next week.
Mhm.
So we should bring ideas, that's what you're, next time.
If we could all kind of brainstorm, maybe take this time between now and the next meeting to look over this material and say, you know, it would be really great if we all knew about this, or gift laws in particular, or conflicts of interest, or whatever sections seem pertinent. I mean, it's all very pertinent, but
I mean, I think you can discuss it because it's related to commission training.
Okay.
It's just whether or not voting on
Oh, okay.
evaluation for commission standards, that should maybe push on to the next
Yeah.
one, but discussing whether what form additional training would take and
Okay.
how to assess training.
so I would say that this is a lot of information to digest. So being able to make sure that we are well versed enough to at least have conversations about it would be a good step forward. Apparently, it doesn't exist in between previous commissions, or I guess previous members of this commission have never had this before. I think it's a great thing to have.
No, I think this is great training, I think it's good to have, I don't think anyone is gonna, I mean, I've worked with a lot of smart people, but no one's gonna memorize all this stuff, but
Yeah.
to have a general working knowledge of it would be good for commissioners.
So you want us rated or what word, appraised,
Evaluating.
evaluated? Yeah, good idea.
I think that's as far as we need to discuss on that, and then again, between now and next session, we can just kind of brainstorm some key topics on this that we might want to follow up with.
Okay. Does anybody have anything from that they would like more information on?
As we go through it, I can email you.
Okay.
Yeah, I think mine would probably be case by case,
Yeah.
if something comes up.
Okay.
Other items, I guess I had a list here. Things that I didn't see in this material. One other things that we should probably be focusing on are ensuring that we know about the protected classes. Some like at a real fundamental level. So I'm not assuming any knowledge amongst any of us, so I'm just saying things like what protected classes are we actually expected to kind of initiate over. And then from there, we can sort of get into protected areas, I would assume.
That would be included in the training, you're saying, as far as, because I think Latrice went over that
Last time.
last time.
Last time.
Yeah.
Or it'd be including the evaluation.
In the evaluation, okay.
Perfect. Where are we in the minutes?
B, or the agenda?
Yeah, PA dash.
Second,
Oh, yes.
So this is a case that a probable cause decision was issued on. There was a conciliation that was held, it failed. This case involved an allegation of race discrimination and public accommodation. So an individual was shopping at a store. There was an exchange with the person working in the store, and they referred to the individual as a racial slur. They filed a complaint here in our office, and we found that there was probable cause to believe that race discrimination occurred. And did you want to say something?
Yes.
The complainant is here, and he wanted to address the commission before you voted on whether or not to take it.
Good. First of all, I want to recognize the commissioners and show my respect and everything. And I want to address that the guy totally did me wrong, you know. I want to, if you guys having a meeting on this case, I just would like to know if everybody know about my case personally, if know about what happened in detail, you know, and.
I do, they don't.
Okay.
You can tell them though.
Well, I was discriminated against. I'm quite sure you have to know about my case before you can make any decisions about it.
Latrice will give us more information later too.
Okay, well, I did my own research too. It's been about 4 or 5 years since it happened. And I did my own research, and then this is by far not the only incident that happened there like this, you know. And, you know, it's happened with ladies too in my community, you know. And the guy seemed to, that business or company seemed to don't have no respect for my community, our community where I live and anything. And one thing I don't like, it's not fair to the community as well. And it's they have they sell right out the store crack pipes, you know, right there, you know. Kid coming there, the first thing he see at the level of his eyes is crack pipes, you know, and that's been a problem in our community, and for people who don't respect our community to disrespect people in our community, it's not can't live with that, you know. There needs to be something done for it. It's bigger than the guy just calling me a discrimination word, you know. I got to live with that on top of get treated like that and know that they disrespect people in the community that live right there. I believe the man should have to go to some type of acting class, some type of learning class to learn how to treat people, you know. I was born here in America. I don't think he was born here in America, you know. But it doesn't matter where you're from. It's just about treat people with respect anywhere where you at, you know. I catch the bus a lot, and the first thing a message on the bus is please remember to respect your passengers and all the other people. And this guy totally did not treat me like that, you know. And I don't know if it's overlooked, but it's been going on a lot of times. This is not the only incident that happened. I heard of shootings up there at this incident. I heard of windows getting broken because of the disrespect. I've heard of the store getting tore up you know, for him doing the same thing that he done to me. And I would like for this court to address it, respectfully address it, and don't, you know, throw it under the table or nothing, you know. It's taken serious in our community, in my community, you know, for somebody to be treated like that, you know. And like I said, that guy needs to get some more learning, or whoever owns that company needs to get some more training on how to treat people in the community.
Can you tell us what?
Well, I was hurt there at the store. I had an incident and I was hurt, which, you know, that's another incident, but I come to show the guy my doctor's bill, you know, and the guy read him, which he already know because he was there when I got hurt, you know, and he looked at it and he tore it up. And I hate to use the word because I don't like the word used in my community and my family and nowhere, but he tore my paper up and said, "Get out the store, nigger, and don't come back." And I was kind of in shock that he said that to me. And then I kind of paused for a second, and he came around the corner on me, you know, and he came off around the counter, and he stopped there, and I was like, hold up there, hold up, man. And he called me a nigga again and started coming at me again. So I just kind of threw my hands up and bagged out the store. I was there at the door pretty much anyway. And he lied and said that I said something rude to him, which I did not say anything, but what I just told you. And I did exactly what I said. And he tried to get out of it. He said that's our normal language in my community. I can tell you that's not normal for me. That's not normal for me at all. I feel like I'm a blessed human being and I'm not nothing less than that, you know. And I don't think it's fair for somebody to say that to anybody, you know. And I take it serious. He might take it as a small tap on the hand, but I take it that I think he need a stiff penalty and learn the lesson, and I need to be compensated from him. He need to be penalized and know not to treat anybody else like that, you know. And I would think that this office know about all the other incidents. Some of them is more serious, and some of them, you know, but it can't. This is not the only incident with this person, with that business. And one last thing, I don't like the fact that they selling crack pipe and things that can, you know, that's not good and healthy for the communities. Have some apples and oranges under your counter. Don't display those things. That should be against the law. I'm quite sure if any person that have a problem with those type of drugs or something, that will be it. That's you know, easy access is a problem, you know, and you don't need it right in your face. You know, it should, the city of Davenport should make everybody with those things, get them out the store. I mean, they ain't helping nobody, you know. And matter of fact, it causing problems in the community, you know. So that should be stopped right there. And that shows that you're not respecting the people that you're serving, you know. With that, to have the audacity to even put that on the shelf, to sell to anybody. You know, I thought that was something that you smuggled, like a drug or something. You get caught with it, you go to jail. So how can you sell it? Not just about the selling, it's just about respect. I don't want that word ever used to anybody I know, you know. And I've heard he done it to some ladies that couldn't defend themselves. And, you know, lady cried telling me about that, you know, and I think that's very sad. And for the city to not to address a business owner that's, you know, that's supposed to be a servant in the community.
Thank you, sir. Looking at the, I just wanna make sure we have it down. I was going through the names. Your first name?
Laverne,
Laverne?
Laverne Clark.
Okay. Thank you, sir.
So when making a decision on whether or not to take something to a public hearing, we look at the resources, I think we have three cases here that are for public hearing. So we look at the resources of the commission. Whether or not this is a matter of broader public concern, or we feel like it's going to have a great impact on the public. And whether or not there's the resources within the budget, time for staff to devote to the matter. If the commission decides to take a public hearing, we contact the Department of Department of Administrative Appeals, and we use their administrative law judges to start the process of scheduling a hearing. If you decide not to take a public hearing, the parties can then, the complainant can then request a referendum. They can go and pursue that action privately.
Has the office had opportunity to investigate further with other incidents?
Based on the investigation, the information that we found, this was the one incident that we had information on. The allegations were corroborated by the evidence in the record. The investigation didn't have any information about other incidents that would have happened in the community. So with public accommodations, it's really hard to find witnesses because it's basically you're getting information from strangers to have them corroborate kind of what happened. And there may or may not be video footage of what happened, might be deleted by the time the complaint comes in. So public accommodations would usually have much less information about exactly what happened. And there's really kind of no way to identify other people that might have happened to absent the complainants independently knowing.
Yeah, point. Does the statute of limitation fall in place?
No, it was filed in town, it was filed
Okay.
in town, it's fine. It's just yeah, they're usually very few witnesses in a public accommodations cases, it's just whoever was in the store with you at the time, or something, those are the people who
And the respondent, what have they?
they admitted to, what he alleged.
And, excuse me, the police department keep all records of every incident that's, as far as serious enough to report, So it's the records of every incident that happened at Brady Street Market liquor store, at food and liquor store. And they sell accessories. I was there for a phone accessory, Not a big liquor drinker anyway,
Thank you, sir. So that's where we're at as far as making sure that, or weighing in on a decision, take this to public hearing. And we're open to discuss, of course.
Huh?
We're open to discuss.
Yeah.
Okay, so. Alright,
Has there been, sorry, I have a question. Has there been any other complaints?
That would be
Same.
confidential.
Oh,
So we're actually just discussing this complaint based on what we heard.
And you said that it corroborated that.
Yeah, there was a
Big
problem
corroborated.
with copies in the issue,
Mhm.
and it's the respondent did not dispute that they
made derogatory
They
statements.
corroborated.
And, okay. Is it something that could go into mediation where the respondent would have to take some training classes on behavioral
feel like that would
We
be.
tried it,
But they didn't cooperate.
it didn't resolve. I don't
Oh,
It-
know
The
the facts of
behavior
it.
hasn't
Okay.
changed.
I don't know.
No.
Okay.
Okay.
He said he knows.
Probably does, yeah.
But, yeah, we wouldn't know.
So I think that's our starting ground from what we have. We had an incident. Both parties are acknowledging that it did happen. It was attempted to be resolved through mediation. And before that, obviously there was an issue of probable cause. So now that it was not resolved through mediation, it's up to us of where we're here right now to see, should this be taken to public hearing?
I say yes.
I don't see how this could not go to public
Right,
hearing.
I
I think
also,
it's very clear.
I also,
Particularly since the respondent admitted that.
That's the key factor right there.
right, exactly.
And I would like to point out, it's not every case that goes to public hearing. Once it gets to the commission, there has already been a probable cause decision issued. So any case that comes before the commission, we've already investigated and found that it's probable that the commission did it. So, the existence of a probable cause isn't
Okay.
necessarily, it's really based on the resources and the greater impact of the action, of the case.
Within, I listed 3 factors: resources of the commission, public concern, and time for staff. Okay. Should
Public
we?
hearings cost about $7,000.
Okay, so I guess there's an administrative side of this. Well then, where are we at with resources for the commission?
But this would probably start the next fiscal year, so there would be funds for it, but there are also 2 others here, too.
Fiscal is July.
July 1st.
And we have 2 other cases that would also be in this next fiscal. So-
We discussed for public hearing, not necessarily for sure going,
Okay,
the housing one for sure is, but.
all
But
housing
that's
ones go.
funded differently, right?
No, those are funded
Oh.
through the
They-
same fund.
The same funds.
So of those criteria, resources are met, public concern, I am of the opinion that that is met. And then time for staff, I'm of the opinion that that will be met as well.
I would say the only concern I have is just obviously what happened is unacceptable, but because it's only one individual, is the public concerned overall for one incident, for one individual?
Okay.
That's the only thing.
You're asking how do we validate public concern?
Oh.
Yeah. I mean, me publicly, I wouldn't like it as a citizen of the city, but is that something, because is that something we're gonna do for every incident like this?
Well, I don't believe it's only been one incident, but it's only one incident that we know about.
Dealing with the facts that we presented with.
Yeah.
So then how, as far as weighing in on where we go to public hearing, we have 2 other cases that we have to look at. And that, because it depends on resources, the fair housing one automatically goes. But then we have another case that may or may not, so that we need to listen to that one first.
Okay.
Is the housing the H0081?
So PA is public accommodations, ED is education, H is housing, E is employment, C is credit, TR is transit.
That's true.
So do we want to just hold that one and go to the next one?
Yes.
Okay.
Yeah, we'll come back to that one else today, right? After we hear about this,
Yes.
well, that's the plan anyway.
Is that a yes
So what
or no?
happens?
Since you have to leave.
We can't vote.
I mean, you can vote, I think we can vote on that now, if somebody makes a motion for it.
If it has to do with resources though, do we have the resources to have all 3 of them?
Can it be tabled till next meeting?
I'm sorry?
Yeah.
Table till the next meeting.
we can do that.
And I'll make sure that, that
A vote. She's worried about the vote because
Right.
There's only
there's
Yeah.
a question about the,
I mean, I vote for, but if you want to put it on the table, it's,
maybe we table it.
I think it's best to table.
okay.
Well, then, before she leaves though, can we do D? Just go ahead and do D.
The
That's gonna-
resolution, yes.
That's gonna help, I think that's gonna help our numbers later on.
Fine.
I just noticed too that there's something missing. We talked about moving the meeting over there on the other side, and it's
Oh,
not here.
Put it on the next agenda.
Right.
So Michael,
So-
I'm gonna move to D.
I'm sorry, I was supposed to be doing that. Maybe she might have thought commission format was
We talked
the
about
same
it.
as email format.
You have a copy of that, Phil? Of the resolution?
It's in the packet.
Page 30 something, 35.
Excuse me, so today you guys will make a decision to go forward or not?
The current decision is to table this. We're waiting on the vote count. One of our members is going to head out, and that would, we don't have the right amount of members to vote on it.
But if the member was here already, you can vote right now.
That is true. So part of the decision-making process is that we do have to factor in other cases that we have, as far as some of the resources that it takes to go to public hearing.
So you're saying one case can be more important than the other case, and then the other case, it might be important but not important enough. Then that's kind of, that don't sound too fair right there, you know, to any other cases.
Sure.
You know, so it gotta be off some type of factor than just the resources, you know? Or you can pull some resources from somewhere else to make sure all the cases go through,
Let's
you know?
Fair.
hold on this before you leave, if we can.
Patrice,
Um,
how does that work? How do we make the distinction between which cases we acknowledge first?
It's usually based on the ones that have a greater public importance, so if it's like, if it's something where you can tell from the facts that it's occurring with multiple people or through the investigation, we discover that, then that's communicate that. Through this investigation, like I said, with public accommodation ones, it's hard to identify other people that it could have happened to because it could literally be anybody. So
We could table that just for a second. We can come back to talk about that after Linda leaves, but I'm gonna make a motion to rescind the Davenport Civil Rights Commission resolution dated,
4th of February.
the 4th of February, 2019.
I second.
And I guess,
Should probably vote on this. Okay, that's right. Can you go ahead and state what this is?
what do you want to explain?
This is the Davenport Civil Rights Commission resolution. You're,
yes,
Okay.
so Davenport Civil Rights Resolution, that was made, my understanding, I wasn't a part of it, that was made at the time, which I'm gonna use the word stalled the entry of the new commissioners and removing some old commissioners, for the lack of a better term. My understanding is that this resolution, once rescinded, will seat the 3 new commissioners, and then the 3 old commissioners will be more than happy to attend the meetings in a public position.
I think we have to issue a new resolution to
Rescind,
I think a new resolution has to be drafted to rescind an old resolution, or to replace it, I guess.
So who drafts?
And it would have to be voted on too, right?
Yes.
Yeah.
Yeah, well, we're voting on the motion to
To rescind.
rescind, and I guess who drafted this one?
The attorney, Michael, with the commissioners gave their input on what they wanted to say.
I have a question.
So we have to work with
Don't
an attorney?
Until the courts make their decision.
I probably.
True.
Well, then, yeah, let's just get you a record. Let's get Linda's, can we get the vote on, that we have a motion to rescind it? Or, we have a motion, we have a second, can we get a vote?
Excuse me, don't we have to wait until after the, goes through the courts and the judge makes his final decision?
I don't believe we do.
Not unless there's a stay.
Nothing's telling us as a commission that we have to pause our acts at this point.
Are we sure about that?
Yes, so can we vote, because Linda has to go,
Okay.
and I want to be respectful of her time.
Sure. All in favor, say aye.
Aye.
All opposed?
And
I think it should note the individual votes, given the sensitivity of this.
Yes.
Well,
I'm
yeah.
abstaining because I obviously have an interest in the outcome. And
You wanna do a
Susan,
roll call?
Yeah,
you can do
I
what you
know,
want.
yeah.
Okay.
So Linda would be yes.
Oh, yeah, absolutely.
Yeah, she's, yes.
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 For me.
Thank you.
So, wait a minute, I have a question now. So let me get this straight. You just rescinded the resolution without a replacement resolution, like she said that you had to have. I don't understand how that works. That doesn't make any sense. She said that you needed a resolution to replace that resolution, but you never got one, and then you just voted to take out that resolution. And
With a
that's-
motion.
So what needs to happen?
Yeah, so we voted on it, but you're right, there is no
There's
resolution drafted as it. That goes through, now we can take it to the attorney.
Hey, so the item on the agenda is just the February 4th one. So there should probably be some sort of discussion on it. And then a discussion to add a new resolution to the next meeting.
I don't even know what the first one was.
So we can add that to the next meeting.
So for members of the public, they don't know what you all are doing. So maybe there should be some discussion of what is happening exactly.
Okay. I mean, I think the bottom line is, right now, we just voted to rescind the Civil Rights Commission resolution
It's in this
that's dated February 4th, 2019. I mean, that's what we just did.
I'm sorry, I thought that there was a package.
Can you repeat that?
There are no packets.
We could not hear you.
As a commission, we just voted to rescind the February 4th, 2019 resolution that was in place put in place at the time of the commission that was in place at that time. That resolution, we voted to rescind it. Now, and just as they did, we are gonna get the same attorney, I guess Michael, to draft a resolution to confirm our vote.
Now, my concern is that it is up for decision by the courts, correct, Latrice?
Yes, it is.
And so how can you rescind a resolution that hasn't been settled in the courts as of yet?
I'm not speaking, Michael, you're the chair, so you can take over anytime, but as a commission, I think we have a majority vote to act on resolutions for the commission. We have done that. If the court has an order is entered that directs us at any point, we have to deal with that at that time. Right now, we have no orders.
I think we need 2/3 of the members to vote in favor of it.
So 2/3 of the four of us. Well, technically, there's only four of us right now.
So with this in place, okay, do we want to go over the whole thing?
I think you better.
I
Okay.
think you should, I think
I
we have
think you
to.
should.
So obviously we just went over that aspect of the trading with the voting on things. And if you don't have so many people, it needs to be everybody that's in favor of it. So what happened initially was there was Susie, Helen, and Clyde, their term expired November 30th, 2018. The state law says that, first of all, our ordinance says that appointments can only be made if there's a vacancy. So that's the civil rights ordinance. And there were appointments made on December 12th, 2018.
Can you back up?
Oh.
Except in the case of expiration of the office. And then if they step down, then that's a vacancy. Can
So,
you explain that?
Sorry, a vacancy is not created by the expiration of a term pursuant to the Civil Rights Ordinance 2.58. So that's what it says. So then there's the city's interpreting statutes state that when you are reviewing dates for elective officers, or for city officers, you look to code section, chapter 63. So chapter 63 says that if a new appointment is not made within 10 days of the expiration of a term, then the person whose term expires continues for the duration of that next term. The commissioners requested an opinion from the legal department about how that should be handled, because you have our ordinance which states that appointments can only be made in the instance of a vacancy, and a vacancy is not considered an expiration of a term is not considered a vacancy. State law says that an expiration of a term is not considered a vacancy if the person decides to hold over. Common law is if the person decides to hold over, then there's not a vacancy. So you have that issue, and then you have there's a appointment made that's not made in accordance with state law or our city ordinance. So the commissioners wanted an opinion from the legal department of how that was interpreted and why it was handled in the way that it was. They didn't get a legal opinion, so then they got an independent legal opinion, and based on that opinion, it was deemed that they shouldn't take any action and not do anything and wait and let the court decide what the appropriate action, the appropriate next action should be, because the commissioners taking an action would probably not be appropriate. It should be decided by a judge, because there's a conflict with how the ordinance should be interpreted. And so a judge should decide the correct interpretation of the ordinance rather than someone else. So the commission issued this resolution just to say, we're not gonna do anything, we're gonna continue as we were, because this is something that needs to be decided by a judge in deciding what to do with the makeup of it.
Do you have a copy of that legal opinion?
From the commission's attorney?
Yeah.
This is what's incorporated into the resolution. So that was the basis for that decision. After this was issued, the city obtained a legal opinion from Lane and Waterman. Lane and Waterman represents probably about 25% of the respondents here in our office, so they definitely have a vested interest in deciding who's on the commission. And even that opinion just says, you could be right. It doesn't really say.
It isn't source case law.
No. And it still doesn't address whether or not that decision should be made by a judge. It just says, I think if you go to court, you might win. So
We have a copy.
they have,
Yeah, I mean, I think at this point, as we have a quorum, we voted as a quorum to rescind that resolution. And I think at this point, we get somebody to draft the resolution. I guess, I'm assuming, I don't know, I assume Michael would draft it, if he drafted for the commission before, to rescind it. And I think we move forward, that would be my position.
The attorney on that, Michael.
No, not you, Michael, but the other attorney,
and
Michael. I think at that point,
I
as
think we need
in-
all five to vote in favor.
what's the basis
Which
for
five
that?
though?
But what's the basis of that?
Because the law says that if everybody isn't there, then you have to have everybody in attendance to vote in favor of it. So we're missing two people. So if we had,
I thought the law says if we have a quorum, we can move forward.
if you have a quorum on, it says if you have a quorum on voting on, if you have a quorum in attendance, you can vote on, let me read it to make sure.
So Mike up at 7, and you got 4, you can make a vote.
We don't even have 7, right? We don't even have 5 right now.
Well, we do,
I mean,
but we have a
who
quorum.
technically is that 7? You know
Yeah,
what I'm
exactly.
saying?
The
And that's the
three.
question.
But I think no matter what, we have a quorum. And that's
Exactly.
our vote,
I think,
our quorum. And
I think we can move forward.
We've done with the 4.
2/3 of the members
Who are you looking at?
on the decision making.
Are we in the rules, or are we in the ordinance?
Oh, I'm reading the AG thing.
The one we just went over?
The decision making.
I mean, I have the ordinance.
Oh, yeah.
Yes. Which section?
The form.
Which one? What section are you looking at?
I don't have it in front of me.
Oh,
I was
okay, I
looking
thought
for
you
the
were.
ordinance.
Okay.
I was looking at the AG thing that it's on.
I remember going over the one in the AG, but it seemed like it was in either or. It's either
It depends on what the.
on what has been established. And I was under the impression that what ours was for.
Let's see.
See, because I noted in several times we've had to have 5.
Can I get his attention?
I'm not seeing anything. Look.
You had a question from the public?
Oh, what?
You have a question from the public?
I do, you said?
Right.
Yeah, I just one thing, as I'm reading this, the thing that you're rescinding here says that the mayor did an illegal act. So you're telling me that as a civil rights commission, where there's a legal thing that says the mayor did an illegal act, as a civil rights commission, you're willing to rescind that?
Yes.
Wow, that's.
For clarity,
That's
I
rough.
don't think the commission,
That's
either way,
rough.
if you look at it, I don't think the commission had a right to say the mayor committed an illegal act or hasn't committed an illegal act when the mayor was not the subject of our authority at the point. I think that's just not where we are at this point.
But it was, he appointed you.
Okay. Well, then if that's the case, we're rescinding it.
For clarity, an allegation.
You're
Exactly.
rescinding an illegal act by the mayor. The Civil Rights Commission.
Alleged legal act, like Mike said.
Alleged.
Now, if the court case goes through and, it was found
Yeah.
that, none of this was valid today, this was just a waste of time essentially? Is that basically
We have
it?
to move forward.
Not a good look on any of you.
That's,
I mean,
fairly.
court orders, when they come down, I follow them, people follow them, but it happens all the time. I mean, you have rulings that are made, decisions that are made that are incorrect. You've had made decisions that are incorrect and they've been reversed later on. And at that time, the public gets the same result as they would have if it was, I guess, decided correctly the first time.
Well, if I may, we have a member of the public here who this directly affects. Most of us here are activists. This is someone who is actually here from the public. When we waste time here, and especially that lady's time, who isn't even here anymore, when we waste time here going over stuff that could just very well be canceled out with a judge's decision, we're wasting his time. This
No.
guy came here like in good faith, looking for help, and we're here wasting everybody's time from the public who, they deserve better, frankly.
I agree, but the problem was we were not doing anything up until 2 meetings ago. We were not able to make any progress. So the fact that we were actually able to listen to I'm calling you Mr. Laverne because I remember your first name, that's progress, because we weren't there before.
Well, they could, it's two, so the only reference to it is 2.58.080. And it says either 2/3 of the members or all of the commissioners present.
2.58, tell me that again. After.
2.58.080. So that's the only reference to one.
I'd like to ask a question. Of anybody in the room, Susan, you've made reference to the case that Nicole Briesco has in district court at this point. As far as I know, that's the only case that's been filed relating to who's a legal commissioner. Is there anybody in the room that is aware of another one that's been filed?
That is,
I believe Burbesco and Shiley Garrett both have a,
The suit that's
yeah,
in
but
district court
what
only,
he's referring to is the previous with the 3 people and a replacement
Yeah.
is what he's referring to.
well, yeah, to the best of my knowledge, no one, either former commissioners or the city have filed any kind of legal action related to the issue of whether the 3 commissioners,
That's
Susan and Clyde and Helen, turned out or not. And the case that Nicole has in front of the district court
That's separate.
is separate and only addresses actually the legality of the mayor's termination of the former commissioners and these 3. So even if the judge were to rule in favor of Ms. Briesco, that would in essence reinstate the 4 terminated commissioners that were terminated recently by the mayor and put you all away from the table. That would still leave unresolved the other 3 seats. In March, I made a request at the meeting that all the commissioners and the city cooperate in seeking a prompt resolution of this matter so we could get on with business and get it settled. For whatever reason, neither the former commissioners nor the city have chosen to pursue legal
Now,
action.
I'm sorry, we have requested meetings with the city, with the mayor and city council.
But that's not
And they have
pursuing.
not responded.
But that's not pursuing, let me just finish this one point. But that's not pursuing a judicial confirmation of whose position is the correct legal one. And I think that's the only way this can get resolved, because I'm pretty certain legally the commissioners can't decide among themselves
Right.
who
I
sits.
agree with you on
Yeah.
that, 100%.
and that's what he's trying to do, is decide who sits.
But it was my understanding, it has been
And the only reference is
put to the
for closed session,
judicial end of it.
so it's silent, so you.
That
Only
Mike
Nicole's
is filed.
case, there's, to my knowledge, there have been no other filings, Susan. I'd be
So-
delighted if there was.
Yeah, me too. I mean, yeah, this has got to be
I've
resolved
expressed my
one way or
concern.
the other, yeah.
I've expressed my concern to the city, and the perfect example of why is Mr. Clark here has come in good faith to raise a concern, and yet we find ourselves delayed in dealing with it because of this interminable dispute about who properly sits. And if the court says that the appointments in December are not valid of Randy, Pat, and me, I have no problem standing aside.
And we've said the same thing.
Exactly.
Yeah.
So I
mean,
think,
Yeah, we're in agreement with
yes,
this,
okay.
100%.
I think at this point, there's little I can do to contribute to the further resolution of this. So I'm gonna excuse myself. If I'm seated as a commissioner, those of you that have been activists and taken an interest in this, I would be happy to have a non-formal meeting, conversation. There's been a number of things said about what I stand for and what I believe misrepresent who I am and why I would sit on this commission. So if I'm confirmed as a commissioner, I would be happy to meet with one or more of you talk about what the needs are in Davenport and hear your concerns as well.
Really, I just think, as director, are you gonna take our direction as the majority? We feel like we have a quorum, we've made a decision as a quorum, are you gonna take that direction?
I have to take that direction,
All
but
right.
I also think we have to comply with the law.
Yeah, I understand, but I think that this is our direction, that's how we're gonna move forward. If an order comes down and tells us differently, then we'll deal with it at that time. Because otherwise, we're not doing anything, and Mr. Clark's and anybody else's complaint will not be addressed, nobody's,
So-
ever.
Because in reality, there's only 4
Exactly.
commissioners right now, so 2/3 of that 4.
4 that
Thank
have
you.
been accepted by everybody.
We'll see you.
So, there are 7, the other, Susie, Helen, and Clyde, are still holding over their terms. The people who the mayor attempted to appoint there's the issue with the 63, chapter 63 issue with doing it after the 10-day period, but also they were never, the statute says duly appointed and qualified is defined as having taken an oath of office. So in order to take over a seat that is filled, you would be duly appointed and qualified, and so that never happened. You all's were just different because there was a removal action, and so there were vacancies. So handling a vacancy is different than handling replacing someone.
That's great.
I have a question.
And it's-
So their term expires December 3rd, right?
No, November.
November 30th.
Oh, November
So,
30th.
like-
Where did I get
So you saying my case won't be heard? It's
Right
not-
now, we've decided to table, we don't have a quorum to decide your case at this point.
Well, all you need is 4 out of 7, don't you?
And right now, we only have 4 people who are undisputed by everybody.
Including
So if
the
you
lady
unders-
who just left.
And that would include this lady who left, who had to leave. So right now, we do not have a quorum that we could work with to move anything
But
forward.
when that lady was there, you had a quorum or whatever. And when that man was there, you had more than enough to make the decision. I'm like, why you guys won't make them decisions that you need to be making? I don't understand.
We wanted to go forward and look at the other cases because part of our role is we have to consider the resources of the office. And I know that doesn't seem.
Resources, when it comes down to resources, it shouldn't be considered
I
on going
agree.
forward with a case.
That's not
or
fair, but that's what our parameters, that's what the government has set forth. Because we only have so many funds.
So the government already knows what cases that
No.
they're gonna throw
No.
out.
No, we don't know the cases at this point, but we have to consider the public good. Like, even though you were done wrong and it was totally unacceptable, we can't advocate just for you. We have to advocate for the public as a whole.
That was the question that I asked Latrice is, because that was what you were saying, is how do we weigh that stuff, right?
Yeah, I mean,
It
like,
seems like there's a prioritization going on. So the question that I asked Latrice was, how do we do that stuff? And it just seems like the result was, we just have to look at it as a whole. And
you
what is-
gotta make the right decision each time.
Right.
You can't just be going cause somebody wants you to make a decision. You gotta make the right decision. Otherwise, what's the point of having the Civil Rights Commission? What's the point of even having this company?
Well, you would have other options even if we don't act on your behalf. So basically what we're saying, we can't act on your individual behalf. We have to act on not only your behalf, but the public as a whole.
Okay, I understood that.
So
the first time.
if we don't act for you, you would have other options. You still would have other people to go to get help. And I know that it's different and that's not as easy as I'm making it sound, but you still would have other options.
Which of these options are accessible to people without money?
No, I understand. It's
And where do they
definitely
find
more
this
difficult than that.
information?
Seems like the civil rights is designed to just make a lot of this stuff go away or something. You guys don't seem like you're not really trying to resolve problems, resolve it, You saying you gotta, about the budget?
I mean,
You can't make a decision
this
because
is
of some
that's our
budget.
parameters. That's what we're working with. I disagree that we're not trying to get things resolved
Who
and
can't
trying to
make a
concern
decision
the
because
public.
of budget?
I mean, that's.
I don't think that's what we're trying to
It's
do
the
here.
beginning of the fiscal year, there's plenty of money.
Yeah, I would
So
think.
that was just the question that I had.
I
is-
pay my
At the back
taxes.
at the back of the fiscal year, if they need more money, they should ask the city council for it.
Yeah.
Yeah, so that shouldn't be an issue here,
Sure, yeah.
about making a decision.
We-
We should go forward with decisions that need to be made about serious issues here in the community.
No, we understand your position.
And to be clear, like people leaving the commission meeting early who are here, you know, like what was the excuse here? Was she in an emergency? I mean, I took time off work. I work retail. I make much less money, I
Yeah, I
promise.
took time off work too.
We
Me
took
too.
time off from retail to be here, so you have to understand like our position of watching this, it looks super unprofessional. I know, Michael, you were talking about, you know, reviews for who was on the little commission. That would be the weakest link right there, and as a member of the public, like I'm disgusted that that happened, frankly. It was super unprofessional.
Did I hear you right? My case will not be decided on, or?
We did not say that.
Oh,
So we're
I'm-
just going to
Today.
table it.
Yeah.
We can't do it
Yeah,
today
set it.
Well,
because there's only 3 of us left here.
I'm not ashamed to admit, I don't know what you mean by table. Set it aside. I don't think
No,
this
not
is.
set it aside. We're going to decide on it at the next meeting.
Okay. Well, I just hope you guys take it in consideration. Whatever you decide, make a decision on it, you know?
Yes, sir.
Thank you.
And you also have the option to do a right to sue letter.
Well, I would rather you guys make it. That decision is so plain as day. You guys should have made a decision already. You know, it's not that hard to figure it out. But whatever delay is, or whatever the reason is, I would think you deal with this in a respectful, proper way. You know, make the decision on it. You know, there's certain things you don't need to put off for 2 weeks that you can make a decision on it today. You know, when it's obvious what happened, what was wrong. She said the evidence is all there. I mean, what's going on here, man? You don't want to deal with it, or?
I mean, again, the biggest issue is that I think and I think we've talked about this before, is that we have to remember this office is not, we're not hired by individuals. We don't act on individuals' behalf. We act on the public as a whole. So even if your incident was outrageous, if we felt that as a commission that outrageous act is not, we are not addressing the public as a whole, we're not addressing more than one person, we're technically not supposed to take those cases.
Well, it don't have just to do with me. It
And
has to do
that's
with the
something
community.
and that's why it's tabled till next week.
Yeah, and I want to let that be important and be known. This is not just about me, it's about the whole community, you know? Like I said, the guys, what he's selling in the stores automatically show that he don't have the respect for the people he's selling to. He's in that community, you know? And so, it's not like he got apples and oranges on the shelf either, you know? So, commissioners, you guys say you meet here for to help people. You guys should really deal with this in a respectful way, that this guy get disciplined in some type of way, you know? You just can't just sweep everything under the rug. You know, I heard you guys talking about some more important stuff, that them issues can't be swept up under the rug. They got to be dealt with, you know? And I wouldn't even be in a position that I gotta sweep something under the rug, you know? And this is considered I looked at the Civil Rights Commissioner office as a pretty important thing for the United States, you know, and it looked like you guys are just following the trends of the United States, sweeping things under the rug and pushing things over here and over there until you just make it through the day. And we gotta deal with things better than this, man. We gotta face the ugly things, you know? We gotta talk about it.
So I understand, you know, your concern, but at the same time, right now, there's only 3 of us here. And even if we want to vote on it, it cannot happen because there's only 3 of us. And that's why we're not sweeping your case under the rug, but we are going to discuss it at the next meeting.
Okay.
So I don't want you to feel that we're sweeping it under the rug.
It's been like 5 years too, I wanted that to be known, since I've been dealing with this. I at one time I just thought you guys just forgot about it, but I understand it takes a while to investigate and do all of what it takes. But I mean, whoever has a head position or any position, I mean, don't belittle nobody, you know? Don't treat people like that. If it came down from don't even hold that position if you can't be a man and to get the real truth about it, you know? You can't give the real justice out. You shouldn't be in a position to give any justice out, you know? Don't be there getting a paycheck and just looking like you represent and not really representing your position. Because I thought the Civil Rights Commission was for people who's treated wrong and they get treated fair, get some help to get treated right. That's what I thought the commission office was. And it doesn't sound like you guys are really dealing with what you got to deal with. Because of whatever you got, whatever,
They can't even deal with themselves.
well, the codes you're using and all that, it's like, you know, that language y'all talk, you know? I mean, you gotta deal with the real issues here. You know?
Well, we are limited within the restraints of the law, for one thing. We are all volunteer. There's no money involved with us.
Okay.
There's no gift or anything like that. We give of our time very freely. I mean, or nobody would be here if they didn't want to give of themselves and of their time.
Okay, and I want to, my frustration is not acting that nobody's here or nothing. It's just that, you know, if I volunteer a job, I'm gonna do the best job I can do.
Well, that's.
And I would advise anybody else to do it, you know, even if you're getting any money or not, you know, just be the best person you can be with whatever you're doing. And
that's what we are doing. We're being the best that we can be. But there are certain limitations within the law that we have to adhere to. We're not trying to sweep your case under the table or anything like that. I don't want you to even consider that, because that is so far from the truth. It's being looked into. There's not enough here today to take care of it. It's being tabled till next month so it can be addressed more fully.
yes, ma'am. And with that being said, I hope you guys have a nice rest of your day.
Well, we hope you do too, sir.
Yes, sir.
And we appreciate you coming, and we definitely will look into your situation.
I think we left off on the discussion of a quorum.
What do we do next with the resolution? It's-
I would, I would recommend that we table this
Should
and
it
then
be
get
some-
information, because I thought we had majority, 4 of 7. But this says if it's silent, it's 5 of 7.
Who would be the other three?
It's the 3 who we're still holding over, but it's,
I think that will be contested by.
I think we have enough for the quorum. I mean, I think we, as a commission, I mean, I see what you're reading of it, Latrice, but I think we have to move forward with the quorum and to go, if we're gonna do anything. If not, we're not going anywhere.
Is it something that needs to be addressed by the attorney?
This might be the, I think we should table this and then Lovey do some research on it and get, I was always under the impression that 4 of 7 was a quorum, but the ordinance does not say that. It's silent, and so this direction from the Attorney General's office says if it's silent, then it's 2/3 of the members, which is 5 of 7. I didn't realize that.
It's silent for these instances?
For decision making, so our ordinance says for 2.58.080 is for open meetings. That's the only reference to how many votes you need, but this is only for closed session, and it says either 2/3 of the members or all of the members present. The direction for the AG's office says that if the governing legislation is silent as to what is a quorum, then it's 2/3 of the members.
So this would go back years,
That would
then?
be 5 of 7.
in which decisions were being made, is what you're saying. This would go back quite some time.
So we need to do that and see,
My concern is 3 individuals are being questioned, being legally
it's,
in the commission. And if we're gonna give them a vote, then what happens to the other 3 individuals?
I
Who's,
think
You know
that
what
goes
I'm
back to the original, that was the original position of the commission, was it needed to be decided by a judge because they didn't want to be in the position of deciding which way that should go, because it appears to be an action taken that is not in compliance with the ordinance. And so making sure that it's reviewed and decided to be in compliance with the ordinance was the most prudent thing to do at that time.
So I guess I'm still stuck on that last point of, it's always been up until now that 4 has been a quorum, but now.
No, there's been times we've had that.
So for decision making, it's 5 of 7.
2/3.
For having a meeting, I was under the impression that it was 4 of 7.
Just, okay, majority.
Right. But the decision making, you need 2/3. The ordinance is silent either way, but it does say decision making. So maybe that is still, maybe we are still, it has still been right. It's 4 of 7 to hold a meeting and 5 of 7 for decision making.
And in the past, it's always been treated as
who will
just
be those
majority,
other 3?
not the
Well,
5%.
Depends on what it
I think
is.
that's the
Now
reason
it
why
does,
we're.
but in the
No.
past.
No, in the
Okay.
past it has too,
Okay.
depending on.
We've just gone in a circle at this point.
Yeah.
So, let me,
So your recommendation is that you want to do more research on this to
I'm
figure out
figuring out
what, what is a quorum?
well, this,
As far as
the
decision making.
direction for the direction from the Attorney General says the forum is
5.
5
5
to
to
7.
7.
Okay, so we've always been told that it was 4 of 7.
Well,
For having a meeting.
Different.
I thought the Attorney General said it was 4 of 7, unless it's silent, then it's
5 or 7, 2/3.
2/3. That's not quorum.
A quorum could be a majority of the members, or it could be 2/3.
So the majority of the members, which is 4.
4, right. But if it's silent, then it's 2/3.
Many boards enabling acts state what a quorum is, and I guess ours do not. And if the board's law is silent, then the quorum is 2/3 of the members. Now, if we go on prior acts, a quorum has been treated as 4 of 7 for this commission.
To hold a meeting, but not to make decisions.
Well, I thought that was like special meetings or closed meetings. And every decision has not been on 4 to 7?
For like deciding to go into closed session to decide a case, that has been 5 of 7. Or 2/3. It's usually, everybody's usually here.
Yeah, so if that's the case, I mean, we can't do anything, bottom line. If we go 5 of 7, nothing will get done.
At this point.
Well, I don't think it will, period, because nobody's going to court to ask the judge for an order. No one's done that. And it's been going on for 6 months or more.
And maybe that's a question for the commission to decide, if you all want to ask that be reviewed by a judge.
Have a quorum to do it?
Exactly.
Well, we don't have a quorum right
Maybe
now.
the city needs to do it.
I don't understand, you don't got a quorum. There's 5 people right there, and you guys all on.
I'm not, I don't know.
She can't vote.
Okay.
There's technically just 4.
Well, I thought it was the majority of the 7 can make a decision. Seemed like anybody with a group of the majority of the 4 out of 7 should be able to make a decision if they was commissioners. Seem
We
like
don't
it.
have 4, sir, sorry.
Next month.
Hers
Yeah.
isn't.
Yeah, next
I
month.
don't know
Oh, I'm
what
sorry.
statute.
It'll be, the second Tuesday of July.
Yes.
I can tell you the date in a second here.
So, I'm like in a circle.
That would be July 9th.
So I come back on that date, or please do? All right, sir.
Yeah.
Have a nice day.
Thank you as well.
Let me review that. Let me review that. And then,
How do you rescind a
Figure out how to
resolution?
send
By
that.
another resolution?
So-
Which one are you talking about?
How do you rescind a resolution
quorum
by
issue.
another resolution?
Well, yeah,
Yeah.
the goal was to, at this point, have somebody draft a resolution, but if we're saying that like our rescinding of the resolution can't be done by 4, then we're nowhere, we're basically, we're basically right back to the 3 and the 3 and them
So what we
deciding
tried to do
what the
last
3 is. Exactly, that's why this was important to move forward, we would have 7 either way. And if somebody decides later on that 3 or 4, whoever, then that would be decided, but we would have 7 if we rescind this resolution to go forward with. And
But-
continue to
But
work.
with this resolution, you already have 7 because there's Clyde, Helen, and myself.
Well, there's dispute whether Clyde, Helen, and yourself are able to act.
Well, and there's a dispute at the other 3
Exactly.
minutes.
Exactly,
So, I mean,
that's why
it's
we
sort
don't
of
have
a-
7.
Yeah,
Yeah,
yeah, so we won't get anything done.
I'd like to, so legally, you do have 7. Because of the holdover at state law. Let me research the quorum issue, and then I will send something out before the next meeting, just with information of what it is. Just so that you can have that and have reviewed it. Individuals who are acting in the role are de facto commissioners, so they do have authority to act. It,
we're acting in good faith.
right, so there's, yeah, that's, let me research that first.
So is it your position that the 4 of us, the quorum, we can't approve the minutes, approve the agenda and all that too?
No, 4
At
can,
this point, I,
4 can approve the agenda and the
it's just
minutes.
decision-making.
Where's
To
that,
take
what's the
an
basis
action.
of that though? Was that?
That's
where-
in the between the AG and the, see, that's where I'm
Yeah,
confused too, because
confused,
I'm
yeah.
like, I don't,
But that's what we've done in the past for approving the agenda or the minutes.
that's
The-
true,
The 4,
that's true.
and then for any major decision, it's always been the 5.
That's true. I didn't, okay.
Helen, were you and the other commissioners sworn in?
Pardon me?
Were you and the other commissioners sworn in?
I became a commissioner in 2015.
Were you sworn in?
Yes,
We have to put that in the agenda as well.
I have a action item on that.
I mean, I think we have to decide as a commission if we can, are we comfortable acting on approval of agenda, approving of the minutes, approving on general decisions, except maybe special meetings and closed meetings? If not, then,
see, no,
I mean, everything we've done today,
Well, you had 5 though, until she left. Even the adjournment, I'm like, because she's not here.
Yeah, you can't do nothing now that you don't have people. I don't understand
See, in
why,
the
I don't
past,
understand
we've
why
had like
the
3
commissioners
people
just get up and leave during the day. That's not
but
professional.
we have
Or
4,
it's been a
We're 4,
meeting,
yeah.
But not any decision.
but we are 4.
So, yeah, maybe. I would say,
So we need more research to be done, and
Yeah.
we are leaning towards tabling what we have currently.
and we can go over it, just to have that information.
We would need to, if we can, I would still like to go over the other case.
Okay.
That way,
Other two?
yes, that way come next month,
You
Mr.
got
Laverne as well as the other two will be more informed.
Okay.
Well, I think you're gonna still, I guess I'm thinking not going over both of them, because even if we go with these four,
Yeah.
we don't have, I
But
mean,
just
she
to
still
have,
needs to
just
hear.
to have the information.
But you
So
told,
we would have to redo the information
we have to
so that
redo it.
Linda would be up to speed.
I could contact her.
I mean, I don't wanna rely on, I mean, obviously her schedule is tight.
Yeah.
I mean, I think it's better to do it as a whole versus trying to piecemeal it. It's one thing
Over
to do
the facts of the
training.
case?
Yeah, I mean, it's one thing for the training, but it's a different thing for the facts of the case, I'm thinking.
We,
Yeah, it's better to hear the same thing.
So there's no dispute.
I understand. Let's,
what we could do is we could go over it and then go over it again at the next meeting if that's.
I don't see the harm in doing that.
I guess I don't,
Is it a time?
yeah, because I don't think that makes sense for me to go over it twice. Especially if I don't know if I can vote on it either way. I'm getting a little frustrated at this point, because I really thought we were gonna start moving forward and be able to answer questions for the public
Yeah.
and do things, but not being able to go forward this is frustrating to me.
For all of them.
I'd like to go ahead and get the information out, and if we have to duplicate that next meeting, we do that. But I personally would feel better, and I don't see an issue with having duplicate knowledge.
Okay.
I have a question. What are we waiting from the courts? And when are we expecting to have it?
So they, Nicole and Shiley filed an appeal of the removal.
Mm-hmm.
The removal was based on basically the resolution and them not changing their mind on the resolution.
Mm-hmm.
So the court would likely rule on the removal action and whether the underlying rationale for the removal action was appropriate.
Sure.
So it probably would address the three commissioners.
Right.
I don't know when the decision on that is gonna come out though.
I was told by legal that we're looking at around 45 days. That was a ballpark guess, but that does give some context.
So for the next month and a half, we won't be able to do anything.
It's hard to
Well,
say.
And it's
Wait,
not
can I
that you
ask a
can't do
question?
anything, that would decide.
Whose legal did you hear that from?
Legal department as a whole. I spoke to all of legal. As far as, I guess the two that are Brian and Tom.
So you spoke with the city's legal department?
Yeah, yeah.
So who's Michael? Who's Michael? Not you, Michael.
Michael who drafted this,
Yeah.
who
Who is
is
he?
Michael.
He works for the city too?
No, he's our attorney, civil rights commission attorney.
But that's not.
Seems like a conflict.
And I don't, Mike is representing Nicole, so he would likely have a conflict, so we, but I think there's enough information that if the commission wanted to issue a new resolution, they could figure out what it wants it to say.
Michael represents,
Nicole and Shiley.
So he's not the commission's attorney, he's some of the commissioner's
No.
attorney.
He was the commission's attorney. That's where it gets funky with the way that this is unfolded.
so he
because
technically
this is-
cannot create another resolution
But the commission can.
because
Yeah.
that would be conflict of interest.
But the commission, I think there's enough information that the commissioners can, if they wanted to create a new resolution,
Yeah.
you would know what you would want it to say.
You want to draft that?
I know.
I would draft it out, but it's, based on what we wanted it to say. But it's, let me figure out the quorum thing.
Okay.
One,
I think
first
that's
things
the-
first.
Yeah, I think that's the most important thing, figuring that out. The next case, I sent everybody a, one of the new people, article about confirmation bias. Everybody have a chance to read it. So, Obviously, at the May 17th meeting, someone came forward and gave allegations of discrimination in education against a child with disabilities. There has been information in the news about that, so we want to make sure that a decision on this case is not based on any outside facts that we've got. So this case involved a child who was deaf. He had he has cochlear implants. His cochlear implants stopped working, and so his mother contacted the school to have an accommodation of a interpreter there. He had an IEP. The IEP said that he was going to have some kind of little device that did captioning. And there was like an FM transmitter that, this is, do not quote me on this. I think it connects to the cochlear implant some kind of way, like the teacher is wearing like a microphone and the transmitter, I think, I'm not totally sure how that device works. Either way, between when they created the IEP, which is, does everybody know what IEP is, first of all, sorry, I'm just giving out acronyms.
I don't.
It's an individual education plan.
So kids with disabilities would get this, they have a meeting based on what their disability is, and then they are given a plan for how the school is going to accommodate their disability. So, the school had just suspended all of the accommodations basically that they had in the IEP without notifying the parent, which that's a totally different law than what we enforce, but there are requirements that you notify the parent, you have a meeting, you decide on new accommodations. That didn't happen. So the first day that.
For that school year?
For this incident.
Because if there's a current IEP, that means there's already a meeting that happened.
Right.
With the parents and the school administration.
Right. They changed what was in the IEP without having a new meeting. So, and that's required under a different law. So, under our ordinance, he had the accommodation the first day. Cochlear implants, based on the information that we got from the respondent, on average take 3 to 5 days to repair. The complainant has, of all the kids in the respondent's database, his have gone out more than other kids have. But that's the average time that it takes to repair them. So I guess, and I don't fully understand how cochlear implants work, and like if they have to cut it out to take it to repair it, or if it's the piece that's on the outside that gets removed and it gets mailed out somewhere and then it's repaired. I'm not entirely sure. But nevertheless, in the respondents, in their research, it takes on average 3 to 5 days to repair it. So the first day there was an interpreter there. The next day there wasn't. And the mom states that she requested an interpreter for the week because she didn't know how long it was going to take to repair it. But also she's envisioning that there is these backup plans to kind of, either way he's going to be covered. So he's at school the whole day and there's no interpreter. The next day, she called infuriated because there was no interpreter. They let him sit through class for the whole day with no interpreter. He had no idea what was going on. The respondent kind of blamed the child and said that he should have done more to make sure that he was accommodated. The respondent. And so the law says that if, also the respondent said that he had these other accommodations that should have been sufficient for him. But the law says that with a communication accommodation, the person who is needing the accommodation gets to decide what is effective communication for them. So it's the one area where the law is a little different for accommodations, because for accommodations is usually you go through the interactive process and kind of figure out what's gonna be reasonable for both parties. But for communication, it's the party who's impacted is getting to decide what is effective communication for them. So one of the things was that the FM transmitter is not effective communication because it comes through like bubbles, and so you actually miss what's being said. And that was documented, that it was not a good fit, but it was just like, no, we're gonna decide if this is fine for you. And
Hence the
then-
interpreter.
Huh?
Hence the need for an interpreter.
But the transmitter only works if the cochlear implant is working. So if the cochlear implant isn't working, then you don't have that. The captioning device probably would have been fine without the interpreter if it was there, but they had just suspended the use of that too without notifying the parent. So, it was a matter of having no accommodations and no communication. And then there was the issue of changing the established reasonable accommodations that were there without notifying the parent. So under the law, you have an affirmative duty to accommodate. And if you fail to meet that affirmative duty, then that's a violation of the law. The facts of that case and the information that we obtained from the respondent indicate that this is not an isolated incident, that this is kind of standard operating procedure, that there is a perception that basically it's on the kids to step up and argue about whether or not the accommodation is being, the required accommodations are being met. And that's, there was no indication that they have like the kids that are between this age and this age, this is what we expect. It seems like that's just like whatever ages they serve, they expect you to know or have the capacity to argue with the adults in the room about whether or not it meets your needs. They didn't deny that the mom requested the accommodation for the week. They just say, oops, kind of fell through the cracks. The person who the accommodation was made with acknowledges that she probably requested it for the week. I just didn't pass that information along to whoever needs to do the accommodation. The service who provides the accommodation knew about the requested accommodation. They called and offered it, and they were told, no, you're not needed. So they didn't come. So there was something fell through the cracks somewhere along the way in that case. But the response sounds like that might be just the way that it's handled. Yeah, so that's that one. The housing case involves an assistant animal. So the respondent in this case is a very large landlord, and he paid the complainant, I want to say $500 before the conciliation, to avoid having to participate in the conciliation. But once the complaint is filed here, if it has not been, if it hasn't been dismissed or removed, the commission is now a party to the complaint. And this was after a probable cause decision had been issued. So it's an open case. We have tried to resolve it, to just have the respondent draft a policy for assistant animals. But he has repeatedly drafted policies that are not compliant with the law. And despite, I just want to say maybe 20 times that, no, you can't have this needs to be.
That's the landlord you're talking about?
Yeah.
The landlord drafting his own policy.
We let them, I mean, we try not to go too far into their decision making. So I mean, as long as the policy is legal, we try to, we try to give them as much decision making capacity in that aspect as possible, because we don't want to, as staff, be drafting their policies for them. So we give them resources of, this is what the law says, here's this resource from HUD, here's this resource from the Right Commission. And we'll even, if and this person has repeatedly pushed back on each instance of what the law says, and I found this, where the Department of Justice allowed this landlord to do this, so I can do this too. And it's like, no, that's not, the law doesn't say that. So I don't know what the facts or circumstances were of the Department of Justice agreeing to resolve a complaint with someone with this language in it that's not compliant with the law. But for our purposes and for HUD purposes, that any policy that we say that's okay, it needs to be compliant with the law. So the landlord has a hang up on having information. So when you have an assistant animal or emotional support animal, anyone who's knowledgeable of your condition can give, can like vouch for you having a disability. And it doesn't have to be a letter that specifies exactly what your disability is. It's just someone who's knowledgeable of your condition. It could even be you if you are receiving like Social Security disability income. That's clear that you have a disability. So he wants it to be where it has to come from a doctor or medical provider. And that's not what the law says. The law says anyone who's knowledgeable of the condition can notify the landlord of a disability and disability related need for a service animal or support animal. So he wants it to be where it's only a doctor or medical professional who's giving the letter. And then he wants to add a portion in there that says, it's illegal under Iowa law for you to lie about this being a service or support animal. So that's kind of viewed as like a threat to people or retaliatory. So that wouldn't be a permissible term to have in a policy. And those are like, from our view, very minor things that we're asking to not do, as opposed to having it go through a public hearing. The violation is not denied. It's very clear that it happened, so there's basically no dispute as to the facts. Public hearing is super expensive. The cost is taxed to the respondent. They lose. Also, the commission has the ability to award damages to the complainant. And I don't know if they signed some kind of outside agreement or if he just paid her. We don't have any documentation of that. So as far as we know, there has been nothing signed. So there could be additional damages awarded to the complainant. There could be a civil penalty awarded against the respondent. So it seems like a very minor ask in comparison to what could be the outcome of it. And that person has been refusing to do that. And then the old business is the same people that I have on the director.
I'm sorry, I have to interrupt. I have to go. I have notes up to 2:30. I don't know if he wants to take notes after 2:30.
I think we have to vote to adjourn, because then we would have,
Yep.
Yeah, should just,
so we table everything.
can we include the meeting location moving over there? This is too small for,
Well, do we have enough to vote to table and to adjourn?
I think to adjourn, we,
Well, actually, to adjourn really don't necessarily have to have a vote. The chair can move to adjourn.
I second.
I move.
You so moved?
I move to adjourn. That's fine.
everything else will just be covered.
Second, yeah. So everything else can
And I
be
will
tabled.
I'll be sending out something this week about the
Yeah.
form thing.
Yeah, that's important.
Or else we're here. I'm not gonna be able to figure this thing out today.
And this
Yeah.
might be something that was asked that they.
Oh, no, that was the people, that was
Secretary.
the,
Yes.
I'm sorry, could you just-
yep.
This might be something that, so the option would be for the three to, take it to have a judge review it to see whether or not the appointment was appropriate.
The three being the,
The December appointees or the,
December appointees. The three who were there are still holding over. Yeah, but depending on what the quorum, what the law says about the quorum, then that might,
Be a determining factor.
yeah, change what the resolution, how that is done. But yeah, so depending on what that says, I can draft a resolution for the next meeting, and we can have that there.
are you able to send it to us and then review it that way? So, or are we not able to do that?
I did do it. Okay.
Sample one?
Yeah,
Tired
draft.
of
So this is
this debacle.
Probably not.
I wasn't expecting to
well,
learn that
Open
quorum is fine.
But if
That's
you're
what
just
I'm worried
right-
about.